In 1941, Congress amended the Agricultural Adjustment Act, which meant that wheat farmers across the United States would be forced to limit their production or face a penalty tax. Filburn owned and operated a small farm in Ohio. With some of his land, he grew wheat to feed his animals, to sell at market, and for personal use. He received notice in the summer of 1940 that he was over-harvesting his wheat crop. The purpose of the act was to control the wheat market, determine allotments for each state, and to allow farmers to vote on the act's provisions. In the act, Congress extends federal regulation to production not intended in any part for commerce, but entirely for consumption and personal use on Mr. Filburn's farm. That Mr. Filburn's own contribution to the demand for wheat may be trivial by itself is not enough to remove him from the scope of federal regulation where, as here, his contribution, taken together with that of many others, is far from trivial. Penalties apply equally whether the wheat is intended for sale or personal consumption. The court has gradually broadened its interpretation of Congress authority under the Commerce Clause. The court determined that the effects of many kinds of intrastate activity upon interstate commerce were such as to make them properly subject to federal regulation. Surplus wheat-producing states supply other states whose wheat production is below the level of consumption and export. Large surpluses of wheat in production have devastated the market, and farmers have needed government assistance to sell their crops. This power of Congress under the Commerce Clause extends to intrastate activities that affect interstate commerce, permitting regulation to restrain self-interest and give advantages to others. If the Supreme Court can find that the Commerce Clause applies here, think of the many ways it could be manipulated by the government to regulate the marketplace. How could this decision be used to affect change in today's marketplace? Can you think of any examples?